Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamlin Kerrigan. I've been practicing law and licensed to practice law in New Hampshire for approximately 37 years and in the Commonwealth of Massachusetts, licensed and practicing for approximately 28 to 29 years. And I'm going to be talking today about commercial evictions in Massachusetts. Basically, sometimes you're a New Hampshire resident or a Massachusetts resident for that matter, and you have a property in that you lease to a business in Massachusetts, and you have a tenant that's not paying or breaching their lease, or the term of the lease is up and you want to sell the property. There might be a variety of reasons why you want to remove that person from the property, and I'm going to be talking about the eviction process and that. In Massachusetts, residential tenants have quite a few rights in the Commonwealth of Massachusetts. Commercial tenants have much less rights in Massachusetts, and I've done a lot of commercial evictions in Massachusetts. Basically, you have a notice to quit requirement. You have a lease that you want to, or a tenancy relationship you want to end. One of the first things you want to do is, of course, look at the lease itself and see specifically what you're dealing with. Are you dealing with, now they're done with their term and they're on a month-to-month, so they're what we call a holdover tenancy. Or they never had a lease at all, they just had a month-to-month to begin with. Or there is a lease and they're still in the term, maybe it's a 1 year, 5 year, whatever it may be term, but you think that they did something wrong. They didn't pay their rent. Maybe they didn't pay, they were supposed to be paying taxes or what's called common area maintenance expenses. They weren't doing that. Or they were subletting to a tenant that they didn't get approval of. Or they assigned the lease. They say that they're assigning it, and the lease specifically says you can't assign the lease as a tenant without permission, written permission by the landlord. All of those or any other reasons of a violation of the lease can be good cause to terminate the tenancy. Generally, for a termination of tenancy that's non-rent related, you give a 30-day notice. And it can be in a letter format. You have to state what clearly who the tenant is, and if there's any guarantors, I'd recommend you provide them. If you're in a situation, it's rare, but if you're in a situation where you have a agreement with the tenant that you're supposed to be notifying the mortgagee, meaning the bank, the person that's the borrower is the mortgagor, the person that's the lender is a mortgagee. So if they have a leasehold, or they have some interest in the leasehold, or maybe they're a secured creditor on the assets, they want to know about the termination of the tenancy. If you've signed an agreement as a landlord, you want to notify them, so you want to take a look at that landlord non-interference agreement or consent agreement. But look at those provisions, and then generally it makes sense to talk to an attorney. Again, I've done a fair amount of these for my clients. You then do the eviction notice. I prefer to have it served in hand, and I prefer my client or the representative that I'm going to later bring to an eviction hearing, if I need be there, so they can clarify, they can confirm to the court that they've given this notice. I often don't have any objection or contesting of the fact that the notice was given. They're going to have some other reason. Maybe they think that they shouldn't have to pay the rent, or they disagree that the lease provision says what it says. Whatever it may be, you have what's called a summary process hearing on this. Basically, you first have a case structuring conference, a case management conference, where the court on one date has the people show up. If the tenant doesn't show up, it doesn't file any response, then they get defaulted. If they do show up, then they'll schedule out usually 2 weeks later for a trial if the case can't be settled. The court will try to encourage settlement, but if the case can't be settled, doesn't make sense to try to settle, then they'll have an eviction hearing. The eviction hearing itself, generally you don't deal with counterclaims of people saying, well, I'm owed money from the landlord for these reasons, unless there's an argument that I don't have to pay the rent, and the reason I'm being terminated is because of the rent, and I don't have to pay this for these reasons. But if you're saying that somebody violated the lease for non-payment issues, or the term is up, and the tenant wants to argue about other things that happened during the tenancy, generally the focus of the court will be, can the landlord terminate this tenancy? Then later, if there's a claim for damages by the tenant or the landlord, that's a different proceeding. This is a summary process. So in the hearing, the court will will agree to what's called offers of proof, if both sides agree, where the court will hear offers and then consider whether or not they want to hear live testimony, or they might just go right into the live testimony. And I've done this quite a bit in Massachusetts, and it's a good summary process. It does take some time, but it's better than in a situation where you're a residential tenant. They do have more rights there, and you can move forward with it. Trying to negotiate something with the commercial tenant ahead of time without the notice to quit. You can tell them about the notice to quit coming, the eviction notice coming, but you really should be sending that notice to quit and getting that process moving along. So if they don't move out by that time period, you've done everything you're supposed to then file the eviction suit, the summary process. I'm Dan Marr at Hamlin Kerrigan at 603-883-5501, 603-883-5501. If you have any questions, you can give us a call. You can also check out our website, NashvilleLaw.com. Click on my bio and click on my weekly vlogs. This vlog and all others are identified by topic, and you can look at them and see if there's any others that may be of interest to you. Look forward to working with you. The opportunity arises. Thank you.